Hi, everyone. My name is Ian Henderson. I'm the Director of Legal and System Services at the Wisconsin Coalition Against Sexual Assault. You are watching the Prison Rape Elimination Act webinar entitled Advocacy and Confinement Part 2. In November of 2017, WCASA and the Department of Corrections provided a series of regional training opportunities, which featured both the recently revised PREA Advocacy Manual as well as a screening of the new inmate rights video, which was developed by WCASA and DOC. Attendees of those trainings received a copy of the new manual, which included a DVD of the inmate rights video. Copies of those manuals have subsequently been mailed to all programs that were not able to attend the regional trainings. To ensure that this training will be available to all advocates, WCASA and DOC decided to turn the regional training into this webinar. For advocates who attended the November trainings, this webinar will be duplicative. However, for those advocates who were not able to attend, or for advocates who would simply like to refresh their recollections on what was covered in the training, this webinar allows you to access the training at your convenience. Additionally, we hope that programs can utilize this webinar as an opportunity to do an interactive staff training. The regional trainings included an interactive activity at the end of the training, and to preserve that, we have included brief instructions and materials to help guide that interactive activity, which will be available for download on our website. One final note, this webinar is not intended to serve as a PREA 101 training. For that information, please see the PREA webinar entitled Advocacy and Confinement Part 1. It's now my pleasure to introduce my co-presenters, Leah Weber from the Department of Corrections and Alma Mann from WCASA.
Hello, everyone. Hello, this is Alma. So this is Leah Weber from the Department of Corrections. I just wanted to thank you all for joining us for this webinar presentation. If you didn't have the opportunity to join us in person, we have a few learning objectives, things that we hope to move through today, and in the process of, hope that you better understand. So part of our discussion today will include an overview of some general statistics, data that the Bureau of Justice Statistics has provided us with. We're going to talk through some definitions, a bit of statute. You'll learn a bit more about DOC procedure as it relates to some of the PREA standards. You'll have an opportunity to view the inmate video if you haven't already done so. That is the inmate education video. We'll give you a brief overview of the advocacy manual, and as Ian mentioned, you'll have an opportunity to think independently or discuss as a team a challenging but common scenario that some advocates serving survivors in confinement have encountered. So with that information, we hope that you have a better understanding of the Wisconsin Department of Corrections' efforts to prevent, detect, and respond to sexual abuse in confinement. We also hope you will be able to use the knowledge or skills from this training to better provide services to survivors in confinement. And finally, we hope that you will be able to say that you learned strategies to respond to challenging situations when providing services to inmates. So when we talk about the subject of sexual abuse in confinement, really what is the scope? The Bureau of Justice Statistics, again, provides us with this baseline information. 1 in 10 former inmates, adult inmates, report being sexually abused while in detention. I think what's important to note in this statistic is the word reported. The phenomenon of underreporting as it exists in the community also exists in this setting. We know that from that information, about 200,000 adults are sexually abused behind bars every year in the United States. And of those adults, 31% of them report being victimized 3 times or more. And when we turn our attention to the suspect or the perpetrator, data tells us that there are equal rates of perpetration between staff and inmates. So more simply said, staff are perpetrating against inmates at equal rates that other inmates are perpetrating against each other.
Okay, the next few slides I want to briefly cover some statutory language. And for many of you, this very brief overview of Wisconsin sexual assault laws will be certainly not new information. And the reason we're including this is to highlight some of the areas in which Wisconsin statutory law regarding sexual assault differs a little bit from the PREA standards. And in many cases, as we'll see, the two overlap pretty nicely. However, there's a couple of areas where the PREA standards include behaviors that would fall under PREA and fall under then requiring a DOC response that might not be covered by Wisconsin statute. So I just want advocates to understand some of those situations so that if you're responding to an inmate who experienced sexual abuse that might fall under the PREA standards but not under Wisconsin law, you can understand where those differences lie. So when looking at Wisconsin sexual assault statutes, there's a few key terms that crop up commonly throughout all the statutes. And again, for advocates, these will be, again, I'm sure, very familiar definitions. The first one is the definition of sexual intercourse. And you can see up there that Wisconsin has a broad definition of sexual intercourse that includes vulvar penetration and as well as oral sexual assault or penetration by any part of a person's body into the genital or anal opening of the victim, either by the defendant or upon the defendant's instructions. It also includes penetration by objects. And so our sexual intercourse definition, again, is broader than probably what the average person would define as sexual intercourse. One of the other key terms utilized in Wisconsin's sexual assault laws is sexual contact. And that is defined as an intentional touching of the intimate parts, which has a specific definition in the statutes, either directly or through the clothing. And there's a few more elements than what is described up on the screen, but that intentional touching must be for the purposes of arousing or gratifying the defendant, or humiliating or degrading the complainant, or which would meet the definition of an actual or attempted battery. In other words, a touching that causes bodily injury. And finally, consent. Consent is defined in Wisconsin sexual assault laws as words or overt actions indicating a freely given agreement to have sexual intercourse or contact. Again, that must be by a person who is competent to give informed consent. Now, we know, and we'll see in a second, that with respect to staff on inmate sexual assault, consent is not an element. However, for inmate on inmate sexual assault, consent may be an element that would need to be proven by the prosecution to convict a perpetrator. So we're including the consent definition for those reasons. I also want to direct your attention to the Wisconsin jury instructions, which are tools that are developed to help jurors as they're deliberating cases and deciding guilty or not guilty. And the jury instructions for consent says as follows, that in deciding whether the victim did not consent, consider what the victim said or did along with all other facts and circumstances. One thing to note is that this jury instruction has a particular focus on the victim and the victim's behavior. And again, note that that victim focus often leads to victim blaming. And so we can see some challenges that are with this jury instruction inviting that victim focus. However, I want to also bring your attention to that final clause about along with all other facts and circumstances. And prosecutors who I've trained with on this topic have said, well, that's that last part, the all other facts and circumstances, that's the opportunity for prosecutors to introduce and talk about those offender focus themes to try and shift that focus off of the victim. Because we know that as jurors are examining victim behavior, they often do so through a lens clouded by rape myth and victim blaming. And second-degree sexual assault. I'm bringing this statute up because this specifically talks about what will be staff on inmate sexual assault. And you can see on the slide the elements that are required for a prosecution under this particular charge of second-degree sexual assault. Note the use of the term sexual intercourse and contact, which we've already talked about, but note that consent is not an element in these cases. and that would be due to the power imbalance and the disparity in power between someone who is a staff person at a correctional facility and an inmate. Okay, the next few slides are highlighting some differences between the terminology utilized in the PREA standards compared to Wisconsin sexual assault laws that we just focused on. This slide, first thing to note would be the difference in terminology with respect to sexual assault versus sexual abuse. The PREA standards use the phrase sexual abuse. As we know, Wisconsin law uses the term sexual assault. This slide is also referencing inmate on inmate sexual assault or sexual abuse. What's highlighted on the screen is intended to sort of help guide you through the volume of information that's on that slide. Again, referencing this is offender on offender. Lack of consent is an element here. And much of what's on that screen would be covered by Wisconsin statute. The last bullet point note that it includes an intentional touching of the inner thigh. The other body parts that are mentioned in that bullet point would fall under the definition of sexual contact, but note that the PREA standards include the inner thigh. So it's possible that an advocate could be responding to sexual abuse that falls under the PREA standards, non-consensual sexual contact of the inner thigh that would require a DOC response that Leah is going to talk about in a little bit, but might not fall under Wisconsin statute. The other thing I want to call your attention to is that consensual sexual contact or sexual intercourse between inmates is an administrative code violation, and inmates can be sanctioned through that administrative process. Okay, this next slide, also referencing sexual abuse, but this time by a staff member. So this is where consent is not an element, or note that the PREA standards use the phrase with or without the consent of the offender, meaning the inmate can't legally consent to sexual contact or sexual intercourse with a staff person under the PREA standards, similarly as they cannot under Wisconsin law. Note some of the differences here too on the third bullet point, that staff contact between the mouth and any body part would be sexual abuse. When the staff engages in that on an inmate, that would not be covered under Wisconsin sexual assault law under sexual contact. And then notice also the final two bullet points on the slide, that any display of uncovered genitalia in the presence of the offender or voyeurism also falls under the sexual abuse definition regarding staff on inmate sexual abuse. And lastly, sexual harassment is also covered under the PREA standards. It's likely that for the most part, advocates will be responding to sexual abuse that happens in a Department of Corrections institution. But note that DOC is required to respond to sexual harassment in their facilities as well, and that includes sexual harassment by inmate on inmate as well as staff member on inmate. And you can see, again, what is included in those particular categories, both staff on inmate and inmate on inmate. And without further ado, I'm going to turn it over to Leah, who's going to talk about some of the DOC responses regarding PREA.
Thanks, Ian. So again, this is just a brief conversation about the policies and practices that DOC has implemented in response to the Prison Rape Elimination Act. I know that as advocates, you all may have responsibilities to respond to other confinement settings. And if that's the case, just take this information with a grain of salt. Know that it doesn't extend to all jurisdictions. Some of it surely might be meaningful to those facilities, or you might encounter that facilities have implemented similar policies or practices, but this information specifically is regarding the Wisconsin Department of Corrections. We break up the standards into three categories, that of prevention, detection, and response. And again, I just want to go through some of our our responses to the standards in broad strokes. I don't want to get too deep into the weeds. We hope that you will review the Advocacy and Confinement webinar, the first part of this webinar, for a more 101 introduction, but I do want to give you a brief overview, as I think understanding our policies and practices might better inform how you respond to an inmate or a survivor. So first and foremost, we are required as a department to have a zero tolerance policy. We do have that. It's written down in our what we call Executive Directive 72. So that policy is very clearly noted in our policy, and it's both a zero tolerance for sexual abuse and sexual harassment, in addition to report-related retaliation. The standards require that the agency, being the Wisconsin Department of Corrections, has a PREA coordinator. We call this position the PREA director, and this person is really responsible for coordinating the response to the PREA standards, making sure that all of our all of our facilities are working towards complying with the standards. And there are a host of tasks that are required within that job duty. In addition, in a supportive kind of role, every facility has a PREA compliance manager, someone in the facility who is, again, tasked with ensuring that their facility is complying with the PREA standards. This person is usually a security director, a superintendent, someone who has the ability in that facility to affect change. So between these two roles, that is largely how we make progress on a lot of the PREA standards. But that's not to say an entire team of people aren't behind those sort of two positions. The department has some hiring and promoting standards. As it relates to PREA, naturally we can't hire or promote anyone who has a history of engaging in sexual abuse, both in the community or confinement. Prior to the standards, the department only conducted background checks on folks at hire. That has changed thanks to the standards, and we now conduct background checks every 5 years. So it's done on a more consistent basis, regular basis, in an attempt to identify any behavior that someone might have engaged in the community that wasn't previously disclosed. There are also some supervision and monitoring standards that are really just an extension of good safety and security practices. We are required to have a staffing plan on record, which captures our levels of staffing and video monitoring in each facility. This plan must be documented. We also have to have a policy and a procedure for unannounced supervisory rounds, and that's really to deter staff sexual abuse and sexual harassment. As it relates to youthful inmates, the Wisconsin Department of Corrections really defines someone as a youthful inmate as being someone who is 17 years old or younger and sentenced in adult court. So these types of folks are few and far between. However, there are at any given point about 24 of these types of inmates in our care and custody. The standards require that we create sight and sound separation between these youthful inmates, so 17-year-olds or younger, and adult inmates. Well, our solution to this particular standard, rather than making facility modifications, which can be quite costly and time-consuming, was to move anyone who fit into this category of youthful inmates to a youth facility until they turn 18 years old, at which time they will be returned back to the Division of Adult Institutions to serve the remainder of their sentence. So for the time in which they are legally a minor, they are housed in a youth facility. There are also PREA-related standards for cross-gender viewing and searching, which really direct the way in which we conduct pat and strip searches of inmates. Specifically, male inmates may be pat searched by female or male staff members, but they may only be strip searched by male staff members. Conversely, female inmates may only be pat or strip searched by female staff persons. We also have to permit inmates to shower, change clothes, use the bathroom, those sorts of activities without being viewed by opposite gender staff members. To ensure that this opportunity exists, staff members are required to announce their presence prior to entering an inmate housing unit. Folks who have limited English proficiency and disabilities must have an equal opportunity to participate in or benefit from the agency's efforts to prevent, detect, and respond to sexual abuse and sexual harassment, meaning we have to make sure our education efforts, our response efforts are inclusive. We have to provide interpreters or provide other alternate accessible materials to make sure that inmates who might not speak English as their first or natural language, or who might have a disability, including learning disabilities, provide them with materials to ensure that they have an equal ability to comprehend or understand such efforts. We cannot provide or offer inmates as interpreters, so we also have to ensure that there are objective or third-party processes in place in order to interpret on behalf of inmates who might not speak English, again, as their first language or natural language. There are a host of education and training-related standards. We have to provide training to all staff members, including volunteers and contractors. We have to provide additional specialized training to healthcare staff members and anyone who would be investigating allegations of sexual abuse or sexual harassment. We do these trainings on a regular basis. All staff are trained prior to their contacts with inmates, and then investigation type trainings are offered regularly throughout the year. So we have several opportunities for folks to receive training throughout the year. In addition, we have to provide education to inmates, both upon intake into the Department of Corrections and then each time they transfer. So inmates should receive a handbook with information in it related to sexual abuse and sexual harassment. We refer to it as the Red Book. As an advocate, that might be how an inmate refers to it if they're ever speaking to you about it. Again, it's a handbook that details what PREA is, some really important definitions, reporting options that they have, some strategies to help keep them safer, the investigative process, how they can receive support services. They really receive in that handbook a plethora of information related to sexual abuse and sexual harassment. In addition, we show them a video. You will have the opportunity to view that video today, and we facilitate a discussion with inmates so that they have an opportunity to ask questions if clarification is needed, so that they have a really clear understanding of any facility-based policies or procedures that might vary from location to location. Also, in an effort to prevent sexual abuse, our agency is required to conduct a risk screening. This is a series of subjective and objective questions that are asked and information gathered at point of intake and again each time an inmate transfers. So this risk screening really attempts to identify who might be at risk of victimization and who might be at risk of abusiveness. Certainly this tool isn't a crystal ball, but based upon some known vulnerabilities, we're able to identify who might be at risk, with the ultimate goal of keeping these folks separate. So not housing someone who is at risk of abusiveness with someone who is at risk of victimization, and it helps to inform the way we program these inmates. And then finally, as it relates to prevention, any facility modifications have to be made with PREA in mind, with an effort to prevent or detect sexual abuse or sexual harassment. Any modifications to physical plant or addition of video monitoring really is just an extension of good safety and security practices. So any modifications we would make would of course be made with the ultimate goal of preventing sexual abuse and sexual harassment. And then we turn our attention to a few detection-related standards. Our reporting obligations as Department of Corrections staff members are pretty clear. We must report any knowledge, information, or suspicion of sexual abuse or sexual harassment, in addition to any knowledge, information, or suspicion of retaliation. We are also required to report any staff neglect or violation of responsibilities that may have contributed to an incident or retaliation. So staff are very clearly trained to comply with this responsibility. This information is available in many training materials, many policies. As an extension of that, we offer many reporting options. So for staff members, they may tell any supervisor, they may report directly to the PREA office, they may report online. We have a reporting link for any third party to report via our public website. Equally as important, inmates are afforded a myriad of reporting options. They include telling any staff member, any safe staff member that they're able to make a report to. We really encourage inmates that this is their best option. Although there are many other options to report sexual abuse, this is the way that their needs are going to be addressed in the most timely way possible. They may also write to any staff person. They can file a complaint through the inmate complaint system. They may also call one of two inmate hotlines, or both, I suppose. But we have two inmate reporting hotlines, 777 and 888. Both numbers are free of charge, meaning inmates do not need to enter their PIN number to make these calls. They are not recorded or monitored in the traditional security sense, meaning they are not monitored or recorded at a facility level. Inmates are required to leave a voice message, so they are recorded in that sense. 888 is slightly different than 777. 777 goes directly to the PREA office, where we retrieve those telephone calls and forward them to the facility for review and action. 888 is a byproduct of the standard that requires us to have an external reporting option for inmates. So this hotline goes to an external agency who fields these voice messages, reroutes them back to the Department of Correction, again, for our review and action. It's important to note that these are voice messages only, and we only retrieve these telephone calls during business hours. So because of that, there is an inherent limitation. Inmates' immediate or emergency needs may not be met if they elect to report using one of these options, which is why we really emphasize that telling a staff person to the extent safely possible is their best way to really flag the attention of staff if they need immediate assistance. We also accept reports from third parties, as I said. That includes family members, friends, any support people. They're welcome to call the PREA office directly. They're welcome to call the facility directly. They may also use the reporting link on our public or external Department of Corrections website. There is a link to report sexual abuse and sexual harassment. Inmates also are notified that they can contact law enforcement directly if they choose to. At this point, inmates who choose to contact law enforcement are really limited to writing to law enforcement to make that report. And then as it relates to response, there are a host of standards that direct how we as an agency will respond to incidents of sexual abuse or sexual harassment. So part of that includes having a written coordinated response plan. It really is a plan that convenes the roles and responsibilities of our first responders, medical professionals, mental health professionals, investigators, facility leadership, and further directs how they might respond to an allegation or an incident of sexual abuse. If we know or receive information that an inmate was abused or is alleged to have been abused at another confinement facility, we have a responsibility to report that information to the head of that other facility. So I think it's important to note that a confinement facility really includes any prison, jail, lockup, youth facility, or community confinement facility. So anything like a halfway house or a residential services program in which an offender is mandated to participate as a part of his or her, as a sanction, a criminal justice involvement, those all are considered confinement facilities. So as a department, if we were to receive an allegation from an inmate that he or she experienced sexual abuse at a youth facility 10 years ago or at a county jail the week prior, we are equally responsible to notify the head of those facilities within 72 hours of receiving that report. As part of our response, there are several healthcare-related response requirements. We have to provide emergency care to the extent we're able, consistent with the level of community care. So we must provide unimpeded access to emergency care, medical care, crisis intervention. We must provide inmates with information about and timely access to emergency contraception and STI prophylaxis. This information or treatment has to be provided free of cost. And if ever sort of the crisis intervention or medical response exceeded what we as a department were able to provide, inmates would always be transported out to a local hospital. Transport out to the hospital would also be necessary for a SANE examination. We would not, our practice is not to conduct SANE examinations or medical forensic examinations on site. We would always transfer an inmate out to a hospital for an independent examination. I think it's important to note that although an inmate might not be able to decline the transport to the hospital, he or she has every opportunity, every right to deny any part of or the entire examination if they choose not to have it. Following that emergency care and that immediate treatment if needed, we must provide some follow-up services, offering psychological supports, medical supports, providing referrals to chaplains or other support persons within our facilities. We also have to ensure that they're connected to outside advocates, and really that is the crux of our conversation today and our strong partnership with you as advocates, as agencies. That really centers around this particular standard. So as you know, the department has a responsibility to ensure that inmates know how to connect with an advocate when needed. Your crisis hotlines are posted in our facilities near your phones, and victim services coordinators are well acquainted with how to connect inmates to advocates when needed. As part of ongoing care, we have a responsibility to create treatment plans, provide referrals for continued care, to actually provide that continued care when it's within our scope, to offer pregnancy tests, to offer STI testing, and of course all of this is done without charge. And then as it relates to investigation, we have an investigation protocol that we have to conform to. We refer all allegations of sexual abuse or sexual harassment that involve potentially criminal behavior to law enforcement. So in addition to really strong partnerships with local hospitals, local advocates, the Department of Corrections has also equally strong partnerships with local law enforcement. Our evidentiary standard is slightly different than it is in the community, than it is for a prosecutor. Our standard is that of preponderance of the evidence. So that really boils down to more likely or not, did an allegation or did an incident happen? So that is the standard by which we are investigating administratively, keeping in mind that any criminal investigation would be conducted by outside law enforcement. Inmates, sometimes a barrier to reporting is the fear of retaliation. So there are standards built in that require us to monitor any victim or reporter for retaliation. And we must conduct that retaliation monitoring for a period of no less than 90 days and more if required or if the situation warrants it. So we have folks in every facility who are identified and tasked with conducting that retaliation monitoring. They are also the victim services coordinators, the folks who are most adept at providing those support services and connecting inmates to you all as advocates. Part of the investigative process, the very tail end of it, includes reporting back to offenders, notifying them specifically of the outcome of that investigation. So inmates receive via mail a letter that indicates whether the case was substantiated, unsubstantiated, or unfounded. And then sanctions, naturally there are consequences for folks who have been found to have engaged in sexual abuse or sexual harassment. For staff members engaging in sexual abuse, the presumptive standard is termination. For inmates who are found to have engaged in sexual abuse, really the consequence is a continuum. It ranges from a conduct report all the way out to outside criminal charges. SAIR stands for the Sexual Abuse Incident Review. That is the final piece of the puzzle following an investigation. When we determine that an allegation is substantiated or unsubstantiated, a team of people meets within the facility to really review the merits of that, the case, try to determine if there are policy or procedure adjustments that can be made, are there staffing pattern adjustments or physical plant modification that needs to be adjusted, are there extenuating circumstances that contributed to this incident, meaning might someone identify as LGBT? Might there be gang or racial motivations or undertones? Really trying to identify what were the motivations and how can we ensure that this doesn't happen in the future. And then there are a few data collection standards. We're required to prepare an annual report, both sort of coalescing our incident-based information and then aggregating all that information and posting it to our external or our public website.
Okay, thanks, Leah. So now we are going to move to showing you the inmate rights video that we talked about a little bit earlier. This was a video that was developed by WCASA and the Department of Corrections about a year ago. The two organizations, in conjunction with an advertising firm and media company who have obviously expertise beyond our respective organizations in developing, professional products like films and DVDs. But with the script, we went back and forth and really worked on that between the two organizations, hoping to really produce information for inmates about the Department of Corrections' response to sexual abuse and confinement. And for advocates, we think it's important for you to be familiar with the messaging that inmates are receiving regarding PREA. So we hope you utilize the video, and again, those DVDs were included in the manuals that were distributed both to attendees of the trainings back in November and have subsequently been mailed out to programs who were not able to attend those trainings. So everyone should have access to the DVDs, and including the version that you're going to see here in the webinar. So without further ado, we will go to the video. All right. Well, we hope you appreciated the opportunity to see this video, and again, know that the full DVD is included in the manuals, which includes 3 different versions. The version you saw today was the one that will be shown to male offenders. There's also 2 other versions on the DVD, one for female offenders and one for youth offenders. Much of the information is the same in those 3 versions, but you will have access to all of those on the DVD. Also would like to let you know that the DVDs have been translated into Spanish, while maybe not reaching the ideal of having Spanish talent reciting or providing the information themselves. It has been overdubbed in Spanish, so know that that is available for inmates who speak Spanish, that they will be able to view and receive information from the video in Spanish. And we hope you have a chance to discuss the video and as a staff, and to talk about what caught your attention about the video, and what do you think were some of the key messages that this video is trying to communicate towards inmates. And again, as far as advocates, how you might apply this in your role. Again, we hope that this video allows you the opportunity to see the messaging that inmates are receiving regarding the Department of Corrections messaging to inmates. The other thing we should say, Leah, is that this video will be shown to inmates who are entering the Department of Corrections and when they transfer facilities, which, Leah, correct me if I'm wrong, most inmates will probably transfer at least one time in their Department of Corrections, their time that they're serving in the Department of Corrections. So you can expect that most inmates will probably see this video probably twice at a minimum. And again, as advocates, something you can incorporate in your work with inmates is an understanding of what information they've received from the Department of Corrections. Okay, next thing we're going to briefly touch on is I'm going to turn it over to Alma, who's going to talk to you a little bit about the revised PREA Advocacy Manual. That was completed at the last summer, in summer of 2017, and has been distributed to programs. Obviously, you all can read the manual. We're not going to go through it in great detail, but Alma just wanted to give you, provide you a couple of key points that we thought is important for advocates to understand, and you can find additional information in that resource.
Hello everyone, this is Alma, and like Ian just mentioned, I'm going to be talking to you about some helpful tips when working with incarcerated survivors. So by now, hopefully you'll be familiar with the dress code. Hopefully you have passed the clearance check, and so you're ready to meet with, your first survivor of sexual violence that is in confinement. First of all, once you meet face-to-face with the survivor, please introduce yourself, your role in the agency that you're representing. It will be very important to discuss the limitations of confidentiality in the first meeting. We need to remain open-minded, just like when we're working with survivors, out in the community. We are going to listen to the information that is being disclosed, by the inmates, and again, remain open-minded and pay close attention to every single detail, because a lot of times we don't have in front of us, all of the supplies that we need to be writing the information down, like we normally do in our office when we are out in the community working in the agency. So we need to be consistent and persistent, and we need to be patient. Just like, again, working with survivors out in the community, sometimes during the first meeting, survivors don't feel comfortable yet to disclose all of the information, related to the incident of sexual assault. They may give you a little bit of information, and then they may change the conversation to something else, and then they may give you, another piece of information that is related to the sexual assault incident. I think one of the other things that we need to keep in mind is that even though we are working with a survivor of sexual violence, they are also an inmate. So we need to talk about boundaries and keep, the boundaries clear. We need to clarify our roles as advocates. And again, we may need to remind incarcerated survivors of this on a regular basis. Because again, we need to remember some survivors may not have any family members or any friends or any visitors. So, they may want to keep the communication going with you, even though they may not be talking about their sexual assault incident. So again, we need to keep on clarifying our roles as advocates. Also, we need to be prepared to address not only the current trauma that the survivor is experiencing, but also post-trauma, that the survivor may disclose. And so you need to be prepared for that. They may talk about a sexual assault that happened maybe 20 years ago or 15 years ago, and they have not talked to anyone about it. This is the first time that they are disclosing the information to you. So, you need to be prepared to deal with that, plus, the current incident. Again, we need to keep in mind that resources are very limited and, inmates live in a controlled environment. So therefore, it is very acceptable and it's important for you to know that, you have the right to discontinue services at any time that you feel like, if you feel that, the inmate is violating, the boundaries, or if the relationship between the inmates and the advocates, is not going very well. Okay, so again, when providing face-to-face advocacy, we just never know when something is going to be triggering to the survivor or the inmates. And so we need to practice some coping skills with the survivor. Some of the ones, again, because resources are very limited in confinement, some of the practical things that we can actually do is maybe suggest the survivor that he can count, very slowly from 1 until 10 or 1 until 20. Maybe practicing breathing exercises in and out, belly breathing. Also, one of the things that may come up is the survivor may disclose suicidal ideation, and hopefully you'll be prepared and familiar with the policy about suicide. But again, it's going to depend on what type of information is being shared with you by the survivor. If you really feel like this is an imminent threat to the survivor or to others, obviously, this is one of the times where confidentiality may be broken. But again, it's going to depend on what type of information the inmate is sharing with you, disclosing with you. So again, then you will need to make the decision if you will disclose to the victim service coordinator or any DOC staff member, if that happens. And so one other thing to remember is that, like I mentioned in the beginning, we're going to talk about the limits of confidentiality. And so the presence of a third party may impact the confidentiality of the information that is being shared. And again, you may want to keep on reminding the survivor about this. The list is very, very extensive, but these are some of the main points to keep in mind. Again, most of the information you are going to find in the PREA manual.
Right, thanks, Alma. And again, know that you can certainly reach out to WCASA to myself or Alma or other staff regarding questions about serving incarcerated survivors, and certainly Leah is also available for technical assistance as well regarding DOC's response. So we want you to know that in addition to the resources we've talked about and what the material we've covered today, that and our contact information is included at the end of the webinar, that you all know that we are available for technical assistance as well. So that brings us to the conclusion of the formal presentation part of the webinar. As we mentioned at the beginning, the regional trainings that were held in person back in November had an interactive exercise component to that. It's obviously a little bit different on webinar doing that, but we wanted to preserve that because we think it's useful. So to talk about some of the common challenges that advocates might experience when they are providing services to incarcerated survivors. So for that purpose, we are going to continue on and include the scenario as part of this webinar. The other thing that I mentioned at the beginning is we have developed some facilitator notes with questions that can be asked, and we're going to include the questions here in the slides as well as guides for what we think were some of the issues that would be that we would hope you would be talking about that are presented by this scenario. And so those materials, those facilitator instructions, are available for download along with this webinar. So without further ado, we'll get to the scenario. Just a reminder that the scenario is also a progressive one, meaning that it kind of builds on information from the previous slide. So to pause the webinar as you are having those discussions, if you're doing this as a staff. Okay, everyone, one question that we hope will guide some conversation would be, what options can you discuss with Michael after this crisis call? I think we can go. Okay, the scenario continues. And the discussion question, what can you as an advocate do to prepare for your visit with Michael at the Department of Corrections institution? Okay, we're now reaching the choose your own adventure portion of this scenario. So there's a couple of different ways in which the scenario could go, and this is the first option here. The discussion question here will be, what are some strategies you can utilize as an advocate should this happen? And finally, the last possibility for the scenario would be on this slide. And what options can you as an advocate discuss with Michael at this point? Thank you, everyone. We appreciate you viewing this webinar today. And again, as we mentioned, we are all available for technical assistance, and you can see our contact information up there. Thank you again for all that you do, and we hope you found the information in this webinar useful. Again, remember that part 1 of the Advocacy and Confinement series can be found on WCASA's website, along with the facilitator instructions for the interactive scenario that we just went through as well for this webinar. Thank you, everyone.
Thank you.
Thank you.
Okay.
That's a wrap.
That's a wrap, Peter.
This is as good as it's gonna get. It's Friday, we have an
I
excuse,
know, right?
and I didn't have enough coffee. It was probably about the same amount of time of doing it in person.
Oh, good luck with that, Peter.
Yes.
What? Oh, the
Well,
recording.
the editing. Actually, you're gonna get a kick out of it.